Okay, thank you. Please be seated. Good morning, ladies and gentlemen. Thank you again very much for coming back and for your service. Very good to see you this morning, and you've all been on time, you've all been attentive, and we certainly appreciate that. Okay, members of the jury, the court will now instruct you upon the principles of law which you are to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions, regardless of any opinion you may have about what the law is or ought to be. You must base your verdict on the law I give you in these instructions. Apply that law to the facts in the case which have been properly proven by the evidence. Consider only the evidence received during the trial and the law as given to you by these instructions, and from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has an impression of my opinion as to whether the defendant is guilty or not guilty, disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. The information in this case charges that Ezra J. McCandless, on or about March 22, 2018, in the town of Springbrook, Dunn County, Wisconsin, did cause the death of Alexander Woodworth with intent to kill that person, contrary to Section 940.01, subsection 1, subsection A of the Wisconsin statutes. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. The defendant in this case is charged with first-degree intentional homicide, and you must first consider whether the defendant is guilty of that offense. If you are not satisfied that the defendant is guilty of first-degree intentional homicide, you must consider whether or not the defendant is guilty of second-degree intentional homicide, or first-degree reckless homicide, or second-degree reckless homicide, which are less serious degrees of criminal homicide. It is the defense theory of the case that Ezra McCandless stabbed Alexander Woodworth in self-defense. The crimes referred to as first and second-degree intentional homicide and first and second-degree reckless homicide are different degrees of homicide. Homicide is the taking of the life of another human being. The degree of homicide, defined by law, depends on the facts and circumstances of each particular case. While the law separates homicides into different types and degrees, there are certain elements which are common to each crime. Both intentional and reckless homicide require that the defendant caused the death of the victim. First and second degree intentional homicide require the state to prove the additional fact that the defendant acted with the intent to kill. First and second degree reckless homicide require that the defendant acted recklessly. First degree reckless homicide requires proof of one additional element, that the circumstances of the defendant's conduct showed utter disregard for human life. It will also be important for you to consider the privilege of self-defense in deciding which crime, if any, the defendant has committed. Self-defense is an issue in this case. The Criminal Code of Wisconsin provides that a person is privileged to intentionally use force against another for the purpose of preventing or terminating what she reasonably believes to be an unlawful interference with her person by the other person. However, she may intentionally use only such force as she reasonably believes is necessary to prevent or terminate the interference. She may not intentionally use force which is intended or likely to cause death unless she reasonably believes that such force is necessary to prevent imminent death or great bodily harm to herself. As applied to this case, the effect of the law of self-defense is: the defendant is not guilty of any homicide offense if the defendant reasonably believed that she was preventing or terminating an unlawful interference with her person and reasonably believed the force used was necessary to prevent imminent death or great bodily harm to herself. A belief may be reasonable even though mistaken. The reasonableness of Ezra McCandless's belief must be determined from the standpoint of her at the time of her acts and not from the viewpoint of the jury now. The standard is what a person of ordinary intelligence and prudence would have believed in the position of Ezra McCandless under the circumstances existing at the time of the alleged offense. The defendant is guilty of second-degree intentional homicide if the defendant caused the death of Alexander Woodworth with the intent to kill and actually believed the force used was necessary to prevent imminent death or great bodily harm to herself, but the belief or the amount of force used was unreasonable. The defendant is guilty of first-degree intentional homicide if the defendant caused the death of Alexander Woodworth with the intent to kill and did not actually believe the force used was necessary to prevent imminent death or great bodily harm to herself. The defendant is guilty of first-degree reckless homicide if the defendant caused the death of Alexander Woodworth by criminally reckless conduct and the circumstances of the conduct showed utter disregard for human life and she was not acting lawfully in self-defense. The defendant is guilty of second-degree reckless homicide if the defendant caused the death of Alexander Woodworth by criminally reckless conduct and she was not acting in self-defense. Because the law provides that it is the state's burden to prove all the facts necessary to constitute a crime beyond a reasonable doubt, you will not be asked to make a separate finding on whether the defendant acted in self-defense. Instead, you will be asked to determine whether the state has established the necessary facts to justify a finding of guilty for first or second-degree intentional homicide or for first or second-degree reckless homicide. The state must prove beyond a reasonable doubt that Ezra McCandless was not acting in self-defense. If the state does not satisfy you that those facts are established by the evidence, you will be instructed to find the defendant not guilty. The facts necessary to constitute each crime will now be defined for you in greater detail. First-degree intentional homicide, as defined in Section 940.01 of the Criminal Code of Wisconsin, is committed by one who causes the death of another human being with the intent to kill that person or another. In this case, first-degree intentional homicide also requires that the defendant did not actually believe the force used was necessary to prevent imminent death or great bodily harm to herself. Before you may find the defendant guilty of first-degree intentional homicide, the state must prove by evidence which satisfy you beyond a reasonable doubt that the following three elements were present. 1, the defendant caused the death of Alexander Woodworth. Cause means that the defendant's act was a substantial factor in producing the death. 2, the defendant acted with the intent to kill Alexander Woodworth. 3, the defendant did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to herself. Intent to kill means that the defendant had the mental purpose to take the life of another human being, or was aware that her conduct was practically certain to cause the death of another human being. While the law requires that the defendant acted with intent to kill, it does not require that the intent existed for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of a defendant in order to convict. Evidence of motive does not, by itself, establish guilt. You should give it the weight you believe it deserves under all of the circumstances. The third element of first-degree intentional homicide requires that the defendant did not actually believe the force used was necessary to prevent imminent death or great bodily harm to herself. This requires the state to prove either, 1, that the defendant did not actually believe she was in imminent danger of death or great bodily harm, or that the defendant did not actually believe the force used was necessary to prevent imminent danger of death or great bodily harm to herself. When first-degree intentional homicide is considered, the reasonableness of the defendant's belief is not an issue. You are to be concerned only with what the defendant actually believed. Whether these beliefs are reasonable is important only if you later consider whether the defendant is guilty of second-degree intentional homicide. If you are satisfied beyond a reasonable doubt that the defendant caused the death of Alexander Woodworth with the intent to kill, and that the defendant did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to herself, you should find the defendant guilty of first-degree intentional homicide. If you are not so satisfied, you must not find the defendant guilty of first-degree intentional homicide, and you must consider whether the defendant is guilty of second-degree intentional homicide, as defined in Section 940.05 of the Criminal Code of Wisconsin, which is a lesser included offense of first-degree intentional homicide. You should make every reasonable effort to agree unanimously on the charge of first-degree intentional homicide before considering the offense of second-degree intentional homicide. However, if after full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of first-degree intentional homicide, you should consider whether the defendant is guilty of second-degree intentional homicide. Before you may find the defendant guilty of second-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. 1, the defendant caused the death of Alexander Woodworth. 2, the defendant acted with the intent to kill Alexander Woodworth. 3, the defendant did not reasonably believe that she was preventing or terminating an unlawful interference with her person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to herself. You have already been instructed on the definitions of causing death and with intent to kill. The same definitions apply to your consideration of second-degree intentional homicide. The third element of second-degree intentional homicide requires that the defendant did not reasonably believe that she was preventing or terminating an unlawful interference with her person, or did not reasonably believe the force used was necessary to prevent imminent death or great bodily harm to herself. This requires that the state prove any one of the following: that a reasonable person in the circumstances of the defendant would not have believed that she was preventing or terminating an unlawful interference with her person. 2, that a reasonable person in the circumstances of the defendant would not have believed she was in danger of imminent death or great bodily harm. 3, that a reasonable person in the circumstances of the defendant would not have believed that the amount of force used was necessary to prevent imminent death or great bodily harm to herself. The reasonableness of the defendant's belief must be determined from the standpoint of the defendant at the time of her acts and not from the viewpoint of the jury now. The standard is what a person of ordinary intelligence and prudence would have believed in the position of the defendant under the circumstances existing at the time of the alleged offense. If you are satisfied beyond a reasonable doubt that the defendant caused the death of Alexander Woodworth with the intent to kill and did not reasonably believe that she was preventing or terminating an unlawful interference with her person, or did not reasonably believe the force used was necessary to prevent imminent death or great bodily harm to herself, you should find the defendant guilty of second-degree intentional homicide. If you are not so satisfied, you must not find the defendant guilty of second-degree intentional homicide, and you should consider whether the defendant is guilty of first-degree reckless homicide in violation of Section 940.02 of the Wisconsin, or the Criminal Code of Wisconsin, which is also a lesser included offense of first-degree intentional homicide. You should make every reasonable effort to agree unanimously on the charge of second-degree intentional homicide before considering the offense of first-degree reckless homicide. However, if, after full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of second-degree intentional homicide, you should consider whether the defendant is guilty of first-degree reckless homicide. First-degree reckless homicide, as defined in Section 940.02, subsection 1 of the Criminal Code of Wisconsin, is committed by one who recklessly causes the death of another human being under circumstances that show utter disregard for human life. Before you may find the defendant guilty of first-degree reckless homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 4 elements were present. 1, the defendant caused the death of Alexander Woodworth. Cause means the defendant's act was a substantial factor in producing the death. 2, the defendant caused the death by criminally reckless conduct. Criminally reckless conduct means the conduct created a risk of death or great bodily harm to another person. The risk of death or great bodily harm was unreasonable and substantial. The defendant was aware that her conduct created the unreasonable and substantial risk of death or great bodily harm. You should consider the evidence relating to self-defense in deciding whether the defendant's conduct created an unreasonable risk to another. If the defendant was acting lawfully in self-defense, her conduct did not create an unreasonable risk to another. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense, and you must be satisfied beyond a reasonable doubt from all the evidence in this case that the risk was unreasonable. 3, Ezra McCandless was not acting lawfully in self-defense. Those are the three elements. Self-defense is an issue in this case. The law of self-defense allows Ezra McCandless to threaten or intentionally use force against another only if she believed that there was an actual or imminent unlawful interference with her person. She believed that the amount of force she used or threatened to use was necessary to prevent or terminate the interference, and her beliefs were reasonable. Therefore, Ezra McCandless may intentionally use force which is intended or likely to cause death or great bodily harm only if she reasonably believed such force was necessary to prevent imminent death or great bodily harm to herself. The circumstances of the defendant's conduct showed utter disregard for human life as the fourth element. In determining whether the circumstances of the conduct showed utter disregard for human life, consider these factors: what the defendant was doing, why the defendant was engaged in that conduct, how dangerous the conduct was, how obvious the danger was, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. You should consider the evidence relating to self-defense in deciding whether the circumstances of the defendant's conduct showed utter disregard for human life. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all the evidence in the case that the circumstances of the defendant's conduct showed utter disregard for human life. Consider also the defendant's conduct after the conduct to the extent that it helps you decide whether or not the circumstances showed utter disregard for human life at the time the death occurred. If you are satisfied beyond a reasonable doubt that the defendant caused the death of Alexander Woodworth by criminally reckless conduct, and that the circumstances of the conduct showed utter disregard for human life, and that Ezra McCandless did not act lawfully in defense of herself, you should find the defendant guilty of first-degree reckless homicide. If you are not so satisfied, you must not find the defendant guilty of first-degree reckless homicide, and you should consider whether the defendant is guilty of second-degree reckless homicide in violation of Section 940.06 of the Criminal Code of Wisconsin, which is a lesser included offense of first-degree reckless homicide. You should make every reasonable effort to agree unanimously on the charge of first-degree reckless homicide before considering the offense of second-degree reckless homicide. However, if, after full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of first-degree reckless homicide, you should consider whether the defendant is guilty of second-degree reckless homicide. Second-degree reckless homicide, as defined in Section 940.06 of the Criminal Code of Wisconsin, is committed by one who recklessly causes the death of another human being. The difference between first and second-degree reckless homicide is that the first-degree offense requires proof of one additional element, that the circumstances of the defendant's conduct showed utter disregard for human life. If you are satisfied beyond a reasonable doubt that all the elements of first-degree reckless homicide were present except the element requiring that the circumstances of the conduct showed utter disregard for human life, you should find the defendant guilty of second-degree reckless homicide. In other words, if you are satisfied beyond a reasonable doubt that the defendant caused the death of Alexander Woodworth by criminally reckless conduct, and that the defendant was not acting lawfully in self-defense, you should find the defendant guilty of second-degree reckless homicide. If you are not so satisfied, you must find the defendant not guilty. You are not, in any event, to find the defendant guilty of more than one of the foregoing offenses. The information alleges not only that the defendant committed the crime of first-degree intentional homicide, but also that the defendant did so while using a dangerous weapon. If you find the defendant guilty of the offense charged, or one of the lesser included offenses, you will be asked whether the defendant used a dangerous weapon during the commission of that crime. Dangerous weapon means any device designed as a weapon and capable of producing death or great bodily harm, or any device or instrumentality which, in the manner it is used or intended to be used, is likely to produce death or great bodily harm. Great bodily harm means serious bodily injury. Before you may consider this question, yes, you must be satisfied beyond a reasonable doubt that the defendant committed the crime while using a dangerous weapon. If you are not so satisfied, you must answer the question no. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless, in your deliberations, you find it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypotheses consistent with the defendant's innocence, you should do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth and give the defendant the benefit of a reasonable doubt if it arises in your minds after you have carefully considered all the evidence in the case. An information is nothing more than a written, formal accusation against a defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not raise any inference of guilt. Evidence is, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated, or which the court has directed you to find. Anything you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at trial. Evidence has been presented regarding other conduct of Ezra McCandless, for which Ezra McCandless is not on trial. Specifically, evidence has been presented of the facts and circumstances surrounding the relationships between Ezra McCandless, John Hanson, and Jason Mengel. Such evidence included the testimony regarding the relationships Ezra McCandless had with John Hanson, Jason Mengel, and Alexander Woodworth. Jason Mengel's reaction to those relationships and the investigation into a sexual encounter between Ezra McCandless and John Hanson. The court has allowed this evidence as panorama evidence to give context to other evidence such as the writings of Ezra McCandless and her emotional and mental state surrounding the relationships with Alexander Woodworth, Jason Mengel, and John Hansen. If you find that these facts and circumstances did occur, you should consider it only on the issues of context and background. You may not consider this evidence to conclude that Ezra McCandless has a certain character or a certain character trait, and that she acted in conformity with that trait or character with respect to the offense charged in this case. The evidence was received on the issue of context or background, that is, to provide a more complete presentation of the evidence relating to the offense charged. You may consider this evidence only for the purposes I have described, giving it the weight you determine it deserves. It is not to be used to conclude that Ezra McCandless is a bad person and for that reason is guilty of the offense charged. Evidence has been presented that Alexander Woodworth wrote certain journal entries in the past. This evidence was presented to you solely because it relates to Ezra McCandless's state of mind at the time of the alleged offense. The issue in this case as to Ms. McCandless's state of mind is whether or not Ms. McCandless, 1, had an actual belief both that there was an actual or imminent unlawful interference with her person, 2, whether or not Ms. McCandless had an actual belief that the amount of force she used or threatened to use was necessary to prevent or terminate the interference, and 3, whether her beliefs were reasonable. It is not to be used by you for any other purpose. The purpose in allowing such evidence is not to support an inference about Alexander Woodworth's actual conduct during the incident. It is not presented to show that Alexander Woodworth had a violent propensity or character for violence. Whether the evidence shows that Alexander Woodworth's writings show a violent propensity, and whether and to what degree such conduct affected the defendant's state of mind at the time of the defendant's conduct, as alleged in the information, is for you to decide. You have heard evidence about Ezra McCandless's mental condition at or around the time of the offense, specifically on the issue of memory. You may not consider that evidence to conclude that Ezra McCandless is not responsible for the offense by reason of mental disease or defect, and therefore not guilty of the offense. First, this is not a mental responsibility case. There is no plea in this case that under Wisconsin law puts mental responsibility in issue. In Wisconsin, the legal term for this defense is known as not responsible by reason of mental disease or defect. However, Ezra McCandless is not raising such a defense. Therefore, you must not use or consider the psychological evidence on the ultimate issue of guilty or not guilty. Psychological evidence has been received by the court, but you may only consider the evidence on the following issues. 1, you may consider the psychological evidence on the issue of whether Ezra McCandless suffered from a condition that presented barriers for her to encode, store, or retrieve memories, or an involuntary response that interfered with her ability to remember. You may also consider psychological evidence on the issue of self-defense. You may consider such evidence when deciding whether Ezra McCandless's belief that she was in imminent danger of death or great bodily harm, or her belief that the amount of force used was reasonable. You may consider this evidence only for the purposes I have described, giving it the weight you determine it deserves. It is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Excuse me. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before you may find the defendant guilty. Evidence has been presented relating to the defendant's conduct after the alleged crime was committed. Whether the evidence shows a consciousness of guilt and whether consciousness of guilt shows actual guilt are matters exclusively for you to decide. Remarks of the attorneys are not evidence. If the remarks suggested certain facts not in evidence, disregard the suggestion. An exhibit becomes evidence only when received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received is evidence, whether or not it goes to the jury room. Attorneys for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact an objection was made. By allowing testimony or other evidence to be received over the objection of counsel, the court is not indicating any opinion about the evidence. You jurors are the judges of the credibility of the witnesses and the weight of the evidence. Disregard entirely any question that the court did not allow to be answered. Do not guess at what the witness's answer might have been. If the question itself suggested that certain information might be true, ignore the suggestion and do not consider it as evidence. During the trial, the court has ordered certain testimony to be stricken. Disregard all stricken testimony. The weight of evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to greater weight than that of another witness, or even of several other witnesses. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experiences in the affairs of life. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and the weight to be given to their testimony. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors. Whether the witness has an interest or lack of interest in the result of this trial. The witness's conduct, appearance, and demeanor on the witness stand. The clearness or lack of clearness of the witness's recollections. The opportunity the witness had for observing and for knowing the matters the witness testified about. The reasonableness of the witness's testimony. The apparent intelligence of the witness. Bias or prejudice, if any has been shown. Possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. The defendant has testified in this case, and you should not discredit the testimony just because the defendant is charged with a crime. Use the same factors to determine the credibility and weight of the defendant's testimony that you use to evaluate the testimony of any other witnesses. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same thing here. Ordinarily, a witness may testify only about facts. However, a witness with expertise in a particular field may give an opinion in that field. In determining the weight to give to this opinion, you should consider the qualifications and credibility of the witness, the facts upon which the opinion is based, and the reasons given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any expert's opinion. In resolving conflicts in experts' testimony, weigh the different opinions against each other. Also consider the qualifications and credibility of the experts and the facts supporting their opinions. During the trial, an expert witness was told to assume certain facts and then was asked for an opinion based upon that assumption. This is called a hypothetical question. The opinion does not establish the truth of the facts upon which it is based. Consider the opinion only if you believe the assumed facts upon which it is based have been proved. If you find that the facts stated in the hypothetical question have not been proved, then the opinion based on those facts should not be given any weight. Evidence has been received that one of the witnesses in this trial has been convicted of crimes. This evidence was received solely because it bears upon the witness's character for truthfulness. It must not be used for any other purpose. Consider carefully the closing arguments of the attorneys, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given you by the court. Now, at this time, ladies and gentlemen, we'll have the closing argument. Yes. Thank you. Please be seated. We'll have a short recess and then we'll take up the matters from sidebar. 10 minutes. So council back in here at 9:25.